preside.
You want me to be seated? All right. Before we begin, let me get, I guess, both Ms. Hubble and Mr. Snyder, if y'all will stand and raise your right hands for her.
Do you swear to tell the truth, the whole truth, nothing but the truth, help you God?
I do, yes.
Excuse me. I'm going to clear up in just 2 seconds. All right. All right, we are here today on the matters of Abigail Guider. We have several different, I think, things that are still pending or things that have been filed. First, there is a motion to have the garnet litem removed from this case that was filed by Ms. Hubble. That was actually placed on Magistrate Robert Rosenberg's docket, but I'm going to hear everything today.
I hope not, Your Honor, because I haven't received any of that.
All right, let me get you a copy of the motion to have the garnet litem
Thank you,
withdrawn
Your
from the
Honor.
case. And we can review that. I'll need to make a decision on that prior to us going forward.
Yes, Your Honor.
So I'll let you look at it and see what type of argument you
Yes,
might
Your
need
Honor.
to make. In this, there. All right. There's lots in here, so I apologize. All right. I believe that all the petitions that should still be on the docket or still be doing something are AC 22383, 223885, PT 223886, and PT 22.
You went a little too fast for us.
Okay, I apologize. Let me do it again. AC 22383. And I'll let me do it this way. I'll find each one and tell y'all exactly what it is. So the AC 22383 was the mother's motion for contempt and for modification of the parenting schedule against father, Sinai Guider. That was filed by Ms. Reguli on behalf of Ms. Hubble on November the 15th of 2016. Then we have AC 223885. That is a petition for contempt for failure to comply with an order of visitation in a parentage case. That was filed that was filed November the 16th of 2016 by Ms. Hubble. Then we have petition 223886. That is a petition to change custody in a parentage case. That was also filed by Ms. Hubble on November the 16th of 2016. And then the PT 22962. 222962 was a petition to modify custody. Oh, that one should be done. That was actually the one from appeal. That was Mr. Guider's petition that was filed, oh, maybe not, filed October the 14th of 2016.
That's new, Your Honor.
Okay, so that's still new too. That was actually filed by the father. All right, we have with us today Mr. Brad Fakes, who is the attorney for the father, Mr. Sinan Guider, who is with us. We have Ms. Lydia Hubble, who is the mother. And then we have Ms. Charlena Mack, who is the attorney, the guardian ad litem for the child. Let me address one other preliminary issue before we address the guardian ad litem, the request of Ms. Hubble for the guardian ad litem. Ms. Hubble, the last time we were here, previous times you were here, you were represented by Ms. Connie Regula in her office. They have since done a motion to withdraw. We reset it to see if you were going to be able to hire your own attorney. And at the last motion docket, you said you did not have your own attorney. I just want to make sure today that you are ready to go forward without an attorney.
Well, today, Cynthia Cheatham is going to be filing a notice of appearance. I mean, she's in Coffee County right now, and she'll be up here after she finishes that up.
All right.
And
Do you have a number for her? Maybe we can call her to confirm that she's going to be here.
she's got an answering service. I don't have a direct number. Also, Judy Mullins was supposed to be here today. She says you continued her subpoena till today, and I don't see her.
Ms. Copeland, if you can call this, once you get to the number, call this lady and see if she's...
Okay, I've got the answering service is 931-728-5313, Cynthia Cheatham.
Cynthia Cheatham.
Mm-hmm.
All right. If you could call and see if she is intending to represent her, so we'll know. All right, and while Ms. Copeland is making that phone call, Ms. Mack, are you prepared to go forward as to the motion to have you removed from the case?
Your Honor, I believe that Ms. Hubble would have the burden of proving.
Oh, she does. I just want, before I ask her
yeah.
questions about that one.
Your Honor, it's the same kind of allegations that we've heard the entire trial, so, yeah.
All right, Ms. Hubble, let me go ahead and hear your argument as to your request to have the guardian ad litem removed from the case.
Would you rather do that than wait for Cynthia to get here? I mean, I can tell you what my argument is.
You can tell me your argument.
Okay. As you recall, we argued against having a guardian ad litem appointed anyway, and part of my concern was that first time around, Ms. Mack, I was really concerned that she did not communicate with my
Your Honor,
child.
objection to any testimony in regards to first time around. We're here on a new proceeding.
Yes, I will
Okay.
sustain that if you would
Okay.
just stick
All
to
right.
the...
Well, this time around, she's apparently not doing any better at monitoring my daughter's well-being while she's supposed to be.
Your Honor, and I would object to any testimony in regards to any allegations unless there's evidence or proof of such that has been obtained by personal knowledge of Ms. Hubble.
All right, Ms. Hubble, tell me not what you... I need you to be succinct, as the guardian ad litem was appointed by the court in order to argue what's in the best interest of the child, to be the advocate for the child. Tell me, why do you believe either that your child does not need a guardian ad litem or that does not need Ms. Mack as the guardian ad litem?
Well, my daughter has her behavior and her emotional condition has deteriorated just
Your Honor,
very.
objection to any testimony in
Yeah,
regards
I
to
need to-
behavior or...
She's correct. I'm going to sustain it. That's part of the, sounds like the case and proof of as to why you're asking for custody. But for this purpose, why is it that you believe either your child does not need, do you believe your child needs an advocate, a guardian ad litem representing her best interest in court? First, just answer that question.
No,
Yes.
I
You do not believe that there's a need for a guardian ad litem to represent?
Right, period. That's my, first of all, I think it just muddies the water, and I think I'm gonna have an excellent attorney. I assume he's got an excellent attorney, I believe, and between us and you, I think we don't need, additional, and it drags
So
it
not
out.
necessarily even about the Ms. Mack, it's just that she doesn't need a guardian ad litem, period.
I think we'll be better off without having a guardian ad litem,
All right,
period.
Mr. Frakes, let me hear, you have any response to that?
Your Honor, my only response would be that throughout my review of the pleadings and the litigation, the mother's made allegations of child abuse against the father. She's actually alleged that he's emotionally, I assume, abused the child. The Supreme Court rule set out the guidelines for when a guardian ad litem is appropriate. I wasn't representing Mr. Gadir at that time. However, the court appointed a guardian ad litem. Therefore, I assume the court has already made the determination that this is a case which it's appropriate to have a guardian ad litem for the child's best interest. There's no point in removing the guardian ad litem at this time, Your Honor.
Okay, and then Ms. Mack.
Your Honor, I would say since October of 2016, the court has heard considerable testimony from educators, from people in the guidance counselors in the classroom that have interacted with my client. I would believe, Your Honor, that because of the allegations that Ms. Humble has consistently made that Delara is not safe in the care of her father, or that she has suffered this, as she just said in her discussions before, that this child, her behavior is deteriorating, her emotional well-being is deteriorating. That's grounds in enough itself to say that there is some dependency and neglect allegations that would warrant a guardian ad litem being appointed. Also, Your Honor, in previous history with this case, there has been consistent allegations against Mr. Gadir for unsafety or brainwashing, or even Ms. Humble
Your Honor,
herself.
I have never made any allegations about threat to her physical safety, and never brainwashing. I don't know where she come up with that.
There has been allegations both in and out of court, Your Honor. Again, we've had the Department of Children's Services on this case that just recently closed their case. That in and of itself, Your Honor, warrants a guardian ad litem being appointed. I believe that I'm in the blessed place to advocate for Delara, although Ms. Hubble does not agree with the fact that I say consistently, Ms. Hubble, follow the court orders, and then we can move on with this. I know my client wants to see her mother. I have consistently come into this courtroom and said the exact same thing, what my client wants. But what my client needs is for her mother to follow the court orders. The child wants her mother to follow the court orders and do what she needs to do so she can see her mom. I've consistently stated that on behalf of Delara as her wishes, and there's been no testimony to say otherwise in regards to that, Your Honor. So it is my position, Your Honor, I believe that I'm best fit because I have the relationship with this child as well as this family, although Ms. Hubble doesn't like how things have gone with this case. But again, it's whatever the court decides if they want to appoint another guardian ad litem, but here's the issue. Who's going to follow up on this case to where we can move forward today? Because it's only going to prolong Delara being able to see her mother, if that will ever happen again.
Okay. All right, I'm going to deny the motion to have the guardian ad litem removed. I do think in this case, primarily because of the history of the case, that there has been a demonstrated need for a guardian ad litem to advocate on behalf of the child's best interest. Due one to primarily some of the allegations that the mother has made against the father as to the safety and well-being of the child, and for clearly the well-being of this child. Because of that, I do think that there is a need for a guardian ad litem, so I'm going to deny the request to have the guardian ad litem removed. I did not hear a lot of argument as to whether Ms. Mack should continue to be as the guardian ad litem. I do think primarily because I believe that there is a need for a guardian ad litem on this case. Ms. Mack has a history of this case. This case has been pending for, or matters in this case have been in front of this court for several years, and Ms. Mack has been the guardian ad litem from the beginning of the first neglected dependency petition, and has the history on the case and knows about the case. So would not remove Ms. Mack from the case. So that motion is denied.
Your Honor, could you appoint a attorney ad litem so she would have someone advocating her desires and preferences?
Ms. Mack, is there a difference between your best interest and your
Your Honor,
clients? Is there a conflict?
There is not a conflict. When an attorney ad litem comes into place is when the child wants something different that I disagree with. But that's in a position where that I could not advocate for what that child wants and presents that. This child has consistently wanted for her mother to follow the court orders so she can visit with her mom. This has been
I haven't seen any evidence whatsoever.
This has been the ongoing situation. There has been testimony by school psychologists, school counselors, school teachers as well that Delara just wants to see her mom, but she wants her mom to follow the court orders. It has been testimony also by supervised visitation workers who have terminated that they just want their mom to do what she's supposed to do.
All right, I'm good.
Okay,
Thank you.
thank you.
All right, I will deny that request as well. There's not been a showing as from the guardian ad litem that there is a conflict in what the guardian ad litem's belief is the best interest for the child and what the child actually wants. So since there's not being a conflict, a demonstrated conflict, then there would not be a reason to appoint an attorney ad litem on that.
And before I forget, I brought you some pictures.
I haven't seen any pictures, Your Honor. I don't think we're at the point of presenting proof in this matter.
Well, it's something, it's my daughter's bedroom, so I don't.
Yeah, that would have to come in
Okay.
for the case. My clerk did talk to the attorney. She is apparently working on a notice to appear now. Or someone in our office, I guess, is working on the notice to appear. She is currently in court, but the attorney is apparently in court, but she will not be able to appear this morning, but it does plan on representing Ms. Hubble. I don't know where that leads us.
May I address the court on a different procedural issue, Your Honor?
You may.
And just in reviewing the file, I've spoken to guardian ad litem and confirmed, it appears the court has taken the petition for modification up first prior to addressing the contempt file. And I didn't know there were two. I assume those have been consolidated now. That
Yes.
the one filed by Ms. Regulate amended the one previously, I assume, that was filed pro se.
Yes.
I understand testimony's begun. There's been actually 2 days of trial, obviously. I'm somewhat concerned that my client's going to have to testify since we're doing the petition for modification first prior to the criminal contempt filed against him. And the rules of criminal procedure obviously allow him the right not to testify against himself, which he would essentially be required to do if he participates in his own petition for modification. Somewhat concerned that it wasn't bifurcated. Obviously, I wasn't involved in the matter. I'm sure there was a reason not to do so, but I'm hesitant to go forward in the modification without having the contempt resolved first, one way or the other, Your Honor.
All right. That does make sense. I will take up the contempts first, and that way your client can choose at that point whether to testify or not. And then
I believe that'll be relatively short.
Okay, we will do the contempts first. Do you all have, I guess we are set to go on Wednesday. Do you all have an objection for us? Did the attorney say she's going to be here on Wednesday? Did
She'll be
you
here
let her
this
know?
afternoon. She said she's coming today. She said that what she's working on, she said she'd be here probably after lunch for the afternoon session.
Yeah, this afternoon's not going to work. I got to get everybody out of the lot at 3. She said we
Really?
call her at 3, at 10. Okay, why don't we take a recess and call the attorney at 10? She's available by phone apparently at 10.
Thank you, Your Honor. May I be excused to sit down in Magistrate Ottman's court
You
very
may.
quickly?
We may.
Thank you.
All right, we'll take a recess. Oh, and so just for scheduling purposes, we are probably not going to come back after lunch today because of I have to get everybody out of the building by 3 and there's some other stuff going on. And since we have Wednesday and some more time next week.
So I just want to be clear. So we're going to call the attorney at 10 to see if she's going to be here for Wednesday?
correct, or I don't
She
know
will,
how
she will be
wants
here
it.
for Wednesday.
We have the Wednesday,
And the
the 18th, the 25th, and I assume if necessary, if we lose today, we can choose another day in the future, but I hope we can resolve this in a day and a half. February.
Yes, I have today, Wednesday, and then next Wednesday, the 25th.
When's your next court date?
You mind if I sit right here, Your Honor? I feel like.
Oh, you're fine.
I'm not part of the team.
Yeah, so we'll see if we can, and I'm not sure, well, I guess we'll have to figure out when we talk to the attorney and what her intent is, if she's representing on all of the petitions, or if she's, I don't know.
May I be excused to step downstairs,
Yes,
Your Honor?
absolutely, we'll
Thank
take
you.
a recess.
Thank you, Your Honor.
Was in recess?
Let me sit down.
Everybody seated?